Your debtor may have a $500,000 home, but it's unlikely that you'll be able to use that to satisfy your judgment. You can't collect what you haven't found. To the first point, in Texas, you're required to check whether there's non-exempt property that can satisfy the judgment before garnishing bank accounts. Failing to do that could result in issues once you send writs of garnishment to the debtor's banks and notify the debtor. You also can't take exempt property such as a homestead. Your debtor may have a $500,000 home, but it's unlikely that you'll be able to use that to satisfy your judgment. To illustrate my second point, missing valuable assets, I had a client who wanted to skip the early investigation to save money. He just wanted to sell some personal property, heavy machinery, that the debtor had left in his yard. I advised him that personal property would not be nearly enough to satisfy his judgment, and it wasn't. And the time that it took for us to sell the debtor's assets gave the debtor plenty of time to move money out of his accounts. To perform an adequate investigation, post-judgment discovery tools are your best friends. This includes property and deed searches, utilizing a quality personal investigator, interrogatories, requests for documents, subpoenas, and depositions. A good attorney knows how to utilize these tools to uncover the debtor's property. And last, mistake number 3, failing to renew the judgment. In Texas, a judgment becomes dormant after 10 years if you don't act. Renewing it keeps it alive and collectible. It's like resetting the clock. I've seen judgment debtors that just don't have any assets right now, but in time they might. It's important to keep the judgment active so that when the debtor strikes it big, you're ready to collect on the judgment and the interest. So if you have a Texas judgment and you don't want to leave money on the table, I'm Robert Binz, and let's turn your judgment into results.